So now we'll be starting with the second theory lecture for judiciary. Okay, so we were done with the first theory lecture, and so naturally we'll be starting with the second theory lecture now. So now we'll be learning, so just a idea of what we learned last time. Last time the topic we learned was about the access to courts, what has been done to make access to courts easier, things of that sort. Now we'll be learning about the criminal justice system. Okay, so basically in India, the criminal justice system is a framework that deals with the detection, investigation, prosecution and punishment of criminal offences. This is what they deal with: detection, investigation, prosecution and punishment of criminal offences. It comprises various institutions including the police, judiciary and correctional facilities working together to ensure justice is served. Okay, the basic goal or objective that they have is to ensure that justice is served. So there are so judiciary actually sort of comes under the criminal justice system. It's sort of like a two-way subset, you could say, but not equal, right? So when you talk about criminal justice system, in a way you can say judiciary is one of the things under the criminal justice system, because you have other things also like police do not come under the judiciary, right? But it comes under the criminal justice system. But then you can also say that the criminal justice system comes under the judiciary also in some sense. Anyway, now just 2 points, 2 articles that we'll be looking at: Article 22 and Article 39A. According to Article 22 of the Constitution, every person has a fundamental right to be defended by a lawyer. All this says is that everybody has the right. So basically, like, see, there might be people from economically poorer backgrounds who are not able to find a lawyer, or who are not able to afford one, because even for lawyers you need to pay good money, right? So basically what this article does is, the objective of the article was to facilitate this for such people, waive off money or even provide them lawyers for free. That was the objective of the article. So basically the point is that every person has a fundamental right to be defended by a lawyer. If a person cannot get a lawyer because the person cannot afford one, it's not that person's fault. It is the person's right to be defended by a lawyer. So it's basically the person's right to get a lawyer to defend them. Okay. Now moving on to Article 39A. This places a duty upon the state to provide a lawyer to any citizen who is unable to engage one due to poverty or other disability. Okay, what does Article 39A say? Basically, a duty is placed upon the state to provide a lawyer. Any citizen should be provided with a lawyer. Which kind of citizens? Who are able to, right? This is again what I said. If a citizen is not able to get a lawyer due to poverty or other disability, this actually particularly comes under 39A. So earlier it used to be under 32, but now if you talk about particularly here, what 39A places the duty upon the state. So in the case where it's the duty of the state to provide a lawyer to such citizens, that comes under 39A. Okay, so this is 39A. When it places the duty upon the state, it comes under Article 39A. Moving on, role of the police in investigating a crime. One important function of the police is to investigate any complaint about the commission. An investigation includes recording statements of witnesses and collecting different kinds of evidence. Okay, so what do we mean by investigation? Basically, you record the statement of the witnesses and you collect different kinds of evidence, right? On the basis of petition, the police are required to form an opinion. This is the role of the police in investigating a crime. Moving on. Now we'll just study Article 22, which we talked about at the beginning in some detail. Right, so there is a difference between both of these articles here. This was one particular, so here since we were talking about criminal justice system, we talked about the fundamental right to be defended by a lawyer. Here we'll be talking about something different. We'll see. Basically, see, an article can cover different things, right? So here we'll be talking about the other things that the article covers. Article 22 of the Constitution of India provides certain rights and safeguards to individuals who are arrested or detained. So these are the following provisions. There are 5 provisions that come under the Article 22. The right to be informed at the time of arrest, the offense for which the person is being arrested. So, okay, first of all, why do we have these rights? Because sometimes the police officials, they misuse their power. So the problem with power is whenever you talk about power, one thing you need to look at almost as importantly is the abuse of power. Okay, because when somebody is at a position where they have power, there is a very high possibility that that person will abuse the power that they have. Basically, for example, see, let's say you are a police officer. Okay, you know what your work is as a police officer, but you have a personal anger towards one person. Okay, it's personal, nothing professional. So it's just some personal anger you have. You use your profession to take out on that person, like you use your profession to vent out your anger on that person. So basically, if I'm a police officer and I have a personal anger towards this person, I just make some fake case against him and I go detain him. I can just go arrest him one day, right? I'm a police officer, I have the power to do that. So such misuse of power, in order to safeguard individuals against such misuse of power, that is why we have article 22 and all of these points. So what does it say? Basically, if you cannot just a police officer cannot arrest a person just like that. The person has to be informed at the time of the arrest, not 2 days later, not 3 days later. At the time of the arrest, the offense for which the person is being arrested, you need to let them know what the offense is. Okay, the right to be presented before a magistrate within 24 hours of arrest. Once that person is arrested, within 24 hours, that person must be presented before a magistrate. Again, why do you have this rule? Because, sometimes police officers arrest people and then they treat them very badly in the cell, right? And they would just be kept in the cell for days or weeks with no, I mean, if the person is innocent, the person needs an opportunity to prove that the person is innocent, right? So because of that, we have this rule that the person must be presented before a magistrate within 24 hours of arrest. The right not to be ill-treated or tortured during arrest or in custody. Then this person should not be ill-treated or tortured during arrest or in custody. This is also again another thing. You cannot ill-treat the person or torture the person. Confessions made in police custody cannot be used as evidence against the accused. Okay, so if there is any confession that you make in police custody, you cannot use that as evidence. Why is that? See, because in police custody, usually, one thing that could possibly happen is that the police could mistreat the people who they have arrested. So that person who has been arrested might not be guilty, but because of the mistreatment as in, physical violence, different kinds of violence, because of that violence, he might have confessed. Sometimes when people force you to say something, there's a lot of pain, there's a lot of torture that you're put under, you might just end up confessing, because what can be worse than this pain and torture, right? So in that case, to sort of counter this point you have, that confessions made in police custody cannot be used as evidence against the accused. A boy under 15 years of age and women cannot be called to the police station only for questioning. If it's just questioning that you need to call a person for, you cannot call a boy under 15 years of age, basically a minor, and you cannot call women to the police station if it's only for the purpose of questioning. That's the other rule. Okay, so this is some things that you have under Article 22 of the Constitution. Moving on. Now we learn about something called the D.K. Basu guidelines. What are these? Let's see. The Supreme Court of India sets specific requirements and procedures that the police and other agencies have to follow for the arrest, detention and interrogation of any person. So, okay, arrest, I think we all know what arrest means. What does detention mean? It's the process of detaining somebody. What does it mean to detain somebody? Basically, when something happens, you take some people, you put them in, you take them to the office for some time in custody. They are not arrested because there's no offense as such that they have done, but you detain them in custody for some time. It's not arrest, but something close. That's what we mean by detention. Interrogation is basically questioning a person, right? Intensive questioning, one could say. So for all three of these, there are specific requirements and procedures, and these requirements and procedures are known as D.K. Basu guidelines. one of the guidelines of the DK Basu guidelines is that the police officials who carry out the arrest or interrogation should wear clear, accurate and visible identification and name tags with their designation. Okay, the ones who carry this out, they should wear the name tags, and their identification should be clear, accurate and visible. They should also mention their designations. Okay, this is what you have under the one of the things that you have under the DK Basu guidelines. Moving on to the FIR, first information report. Once the FIR is registered, the police can begin their investigations into a crime. As per the law, it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offense. Okay, so police, in order to begin their investigation, if it is a cognizable offense, they have to register an FIR. What is a cognizable offense? So basically, certain offenses, so there are two types of offenses, non-cognizable offense and cognizable offense. Non-cognizable offenses are sort of like more serious ones where, you just take them to the court directly. But if that is not the case, you're detaining them or arresting them, in that case, you need a written report. And that is what we mean by FIR, first information report. It has to be written so that you can't just change things later on. It is written, clearly stated, why are you arresting that person, what has been, what are the evidences that you have up until now, all of that things. Okay. So if it is a cognizable offense, it is compulsory for an officer in charge of a police station to register an FIR. Moving on, role of a public prosecutor. A law officer who conducts criminal proceedings on behalf of the state or in public interest. This is the definition of a public prosecutor. Basically, a public prosecutor is a law officer. This person conducts criminal proceedings on behalf of the state or in public interest. Okay, so basically these are things you do either for the state or for the people. The people is what we mean when we say public interest, right? It is the public prosecutor who represents the interests of the state. Their role begins after the police have conducted the investigation and filled the charge sheet in the court. They have no role to play in the investigation. Okay. So, public prosecutor is the one who represents the interest of the state. Their role begins after the police have conducted the investigation and filed the charge sheet. So, basically the police should conduct the investigation, and also there is a charge sheet that you need to file. So, in the investigation as such, the public prosecutor has no roles. It begins after the investigation has been conducted. Okay, it's the proceedings after the investigation has been conducted. Moving on, role of the judge. The judge plays a central role in the judicial system, ensuring the administration of justice and upholding the principles of a fair trial. Here you have some key roles of a judge. Okay, so judge plays a central role, and here are some key roles. Impartial adjudication. What do we mean by impartial adjudication? Basically, the judge should act like an impartial and neutral arbiter, ensuring that all parties in a case are heard and treated equally. They must base their decisions solely on the facts and evidence presented before them. What do we mean by this? Basically, what do we mean by the word impartial? Somebody who is not partial. What do we mean by partial? Basically, if you have some sort of favoritism towards any one group. So, for example, if if a person has his daughter on one side and a random stranger on the other side, there is a very high chance that he would be partial towards his daughter, have some sort of favoritism towards his daughter, right? So, that is an example of partial adjudication. Also another word, this might also be new to you, adjudication. This sort of comes from the word adjudicate. Basically, what do we mean by adjudicate? Pass a formal judgment. Basically, you're passing a judgment as to, okay, this person is right or this person is right, but this judgment is formal. That's what we mean by adjudication, passing a formal judgment about something. Okay, so for impartial adjudication, the judge must be an impartial and neutral arbiter. Basically, the judge should not be biased towards any one side. Okay, they must base their decisions solely on the facts and evidence that is provided before them. Nothing other than the facts and evidence that is provided before them. Okay, coming to interpretation of law. Judges interpret and apply the law to resolve legal disputes. Okay, so you might have to interpret law and also apply it to resolve legal disputes. They analyze statuses, precedents and constitutional provisions to provide legal reasoning and guidance. Basically, the law book should be your Bible or Gita or Quran, the one that you go by. Right, so that's what we mean by interpretation of law. Decision making. Judges evaluate the evidence, arguments, and legal principles to arrive at fair and just decisions. They provide recent judgments that explain the legal basis for their rulings. Okay, so what they do basically, the judges, they evaluate the evidence, arguments, and legal principles. And they arrive at fair and just decisions. They provide recent arguments that explain the legal basis, okay, and they also need to explain the legal basis for their rulings. So this is what we mean by decision making. Basically, you need to be able to evaluate everything that's given and make a decision. Safeguarding procedural fairness. Judges oversee court proceedings, ensuring that all parties have a fair opportunity to present their case, cross-examine witnesses, and challenge evidence. They enforce procedural rules and maintain decorum in the courtroom. So what do we mean by this? Safeguarding procedural fairness. Basically, you have to oversee the court proceedings and you need to make sure that all of the parties, they have a fair opportunity. Nobody is given an unfair opportunity or nobody has their opportunity taken away from them. Everybody needs to have a fair opportunity to present their case. May it be to cross-examine witnesses. So this is usually done by, the lawyer. And challenge evidence. All of these are things that are usually done by the lawyer. The point is, the lawyers on both sides should have equal opportunities to do whatever they want to do. Okay, I mean whatever they want to do, as in anything that is allowed as under the constitution, obviously. Okay, they enforce procedural rules and maintain decorum in the courtroom. Moving on, fair trial. A fair trial is a fundamental right guaranteed by the Constitution of India, and it is essential for the administration of justice. Okay, it is a fundamental right that's guaranteed. It ensures that individuals accused of a crime are treated fairly and their rights are protected. Okay, so this is for people who are accused of a crime. Basically, once they're accused, even after that, you need to ensure that they are treated fairly and their rights are protected. Okay, now what are some key features of a fair trial? Okay, equality before the law. Every individual has the right to be treated equally before the law, irrespective of their background, status, or circumstances. This principle ensures that all parties have an equal opportunity to present their case. Okay, what do we mean by equality before the law? Basically, all that we're saying is that every individual should have the right to be treated equally, irrespective of what their background, status, or circumstance may be. This principle ensures that all parties have an equal opportunity to present their case. Okay, this is what we mean by equality before the law. Moving on, right to legal representation. The accused has the right to legal representation and the assistance of a lawyer. Adequate legal representation helps ensure that their rights and interests are safeguarded during their trial. Okay, basically what you mean by, so see, if there is a person who is accused, okay, and say the person is from a very lower socioeconomic background, that person might not have not be aware of the process of getting a lawyer, or not have enough money to actually afford a lawyer. So this legal representation gives this accused the right to get the assistance of a lawyer and to have somebody to represent that person legally. That's what we mean by legal representation. Adequate legal representation helps ensure that their rights and interests are safeguarded during the trial. So why do you need adequate legal representation? To ensure that the rights and interests of people are safeguarded during a trial. Presumption of innocence. Every person is presumed innocent until proven guilty. This is a very famous dialogue. Innocent until proven guilty. Basically what this says is that you should give people the benefit of doubt. You cannot just treat somebody as a guilty person unless they are proven to be guilty. Okay? The burden of proof lies with the prosecution, and the accused is not required to prove the innocence. Okay? That proving the innocence, proving the guiltiness, proving whether the person is guilty or not lies with the prosecution. The accused does not have to prove that they are innocent. The judge might consider the accused innocent until proven guilty beyond a reasonable doubt. Okay, so there are some cases, see, in some cases, in situations of some crimes, it might not be able to get, proper evidence. I mean, you might have a lot of things that sort of let you, I mean, if you think as a human being with some common sense and whatever intelligent thinking we have, you might be able to know, okay, this person is definitely the person who committed the crime, but you may not have proper proof, right? So, if you do not have the proper proof, evidence, not being able to call the person guilty sometimes an issue, because sometimes there are very there might be people who are very influential criminals who are also very smart, so who get away with things, who might have destroyed evidences, so it might not be so easy to get solid evidence against the person. So if you have, I mean, beyond a reasonable doubt, you can prove that person guilty even if you don't have proper proof. Open and public trial. Trials are generally conducted in open court, allowing the public and media to observe the proceedings. This transparency helps maintain accountability and promotes public confidence in the justice system. So there is something called open and public trial. You have trials in open court, allowing the public and media to observe the proceedings. This helps maintain accountability and promotes public confidence in the justice system. This is why you have open and public trial. Okay, so we are done with this. Just take a minute just to read through all of these 4 points. Okay, moving on. We are still not done. We have 4 more points under fair trial. Right to a speedy trial. Individuals have the right to have their cases heard and decided without undue delay. A speedy trial ensures that justice is not delayed and prevents unnecessary pretrial detention, right? So basically, they have the right to have a speedy trial, because I'm not sure if you have heard this, but this is a very famous quote which also makes a lot of sense. Justice delayed is justice denied. Basically, if you give a person justice if you give the person justice, but if you give it after 10 years or 5 years, it is basically equivalent to denying the person justice, right? I mean, probably not equivalent, but if you deny justice, if you delay justice to a person, it's almost the same as denying them the justice, because they need to get the justice at the time. Like, for example, see, there might be a case where somebody might have done something very bad to you. You would have taken it to court and you got that person under bars, but after 10 long years. So what about those 10 years that you wasted? 10 years where you had to keep going to courts, keep coming back, so much time that you had to waste, because of which you could not, properly complete your education. You had plans of going abroad, but you couldn't do it because you were stuck with this case. So many things, when you delay justice, there are so many things, and even, the mental stress that the person has to go through is immense. So this is a right that was brought against this, that the person has a right to a speedy trial. Okay, basically individuals have the right to have their cases heard and decided without undue delay. This is what we mean by right to a speedy trial. Right to confront witnesses and cross-examination. The accused has the right to confront and cross-examine witnesses presented by the prosecution. This allows them to challenge the credibility and accuracy of witness testimonies. Okay, so basically, if there are certain people might bring certain people as witnesses who are not really witnesses. What do we mean by witness? Somebody who was present at the time of something happening, right? So for example, if there is a murder, Somebody who saw the murder or was like present in, the surrounding when the murder happened would be a witness. Now the problem is people might bring somebody as witnesses who just lie, who say, oh, I saw it, yes, I saw him kill the person, but he might not have seen, right? So you need to have the right to confront and cross-examine these witnesses. So the accused has the right to confront and cross-examine witnesses presented by the prosecution. This allows them to challenge the credibility and accuracy of witness testimonies. Right against self-incrimination. What do we mean by this? The accused cannot be compelled to testify against themselves. They have the right to remain silent and cannot be forced to provide evidence against their own interests. Okay? So basically, you cannot force the accused to testify against themselves, right? You cannot force them to provide evidence. They have the right to remain silent. Right to an impartial judge. The accused is entitled to have their case heard by an impartial judge who is unbiased and free from any conflicts of interest. Okay. So it's important that the accused has an impartial judge who is unbiased and free from any conflicts of interest. The accused should have the right to that, to an impartial judge. Like we said at the beginning, it's important for the judge to be impartial, because if there's a bias, obviously they would prefer that other person, right? So these are just some of the rights that you have under judiciary, under the topic fair trial. With this, we are done with judiciary. So now we are done with all three organs of the government, right? Under which power is separated. So we are done with legislature, and then executive, and now judiciary. Legislature, executive, judiciary. We are officially done with all three organs of the government. Okay, I'll just take you through a quick recap through what all we studied. We started with the introduction. We moved on to the role of the judiciary: interpreting and applying the law, safeguarding individual rights, ensuring the rule of law, judicial review. Then we moved on to independent judiciary, structure of courts in India, where we discussed three courts: district, high, supreme. Then we moved on to different branches of the legal system, where we looked at criminal law and civil law. Then we moved on to a topic on access to courts, where we discussed, about the access to courts. Then we moved on to criminal justice system. We looked at the role of the police in investigating a crime. We looked at the Article 22 of the Constitution, D.K. Basu guidelines, FIR, role of public prosecutor, role of the judge, different roles that we looked at, and then fair trial. Under fair trial, we looked at different rights: equality before the law, right to legal representation, presumption of innocence, open and public trial, right to a speedy trial, right to confront witnesses and cross-examination, right against self-incrimination, right to an impartial judge. These were the 8 rights that we looked at. Okay, so this is basically what we have under judiciary. I'm not sure how we have found the chapter. For me personally, this was my most favorite chapter. Let me know. I mean, you won't be able to let me know, but between executive, so we had union executive, union legislature, and now judiciary. So between executive, legislature, judiciary, which one have you found the most interesting? I'd like to know that. Right. So anyway, this is all that you have under judiciary basically. And yeah, I think that's about it we have under this chapter. It's a good chapter. I mean, obviously we're not fully done with the chapter. We still have, what is it that we have left? Let me know, what is it that we have left? It's an example session. I hope you have not forgotten that. So for every chapter, we have at least one example session, right? So for this, what we essentially have left is an example session, which we will be having. We'll discuss questions. And other than that, the judiciary is pretty much done. We're done with all of this. Now we'll be moving on to other certain things, constitutional, non-constitutional bodies, elections, public facilities, marginalization. Those are the topics we'll be moving. And so we're done with most of the most theoretical parts. We're done. I mean, election and constitutional, non-constitutional bodies, there will still be some theory. But after that, marginalization, public facilities, all of that are topics that you can just read through. But yeah, this is what we have. So we are done with the constitution. We had 3 chapters under constitution, and now we had 3 chapters under the powers. So we're done with all of that for now. So done with judiciary.